Good afternoon, everyone. My name is Melissa Andre. I'm the Executive Director of the Philadelphia Tax Review Board. Today is Thursday, April 3rd. It is approximately 2:06 p.m. Our category today is license and inspection. Please be aware that this is a public hearing and it is being recorded. Because the meeting is public, participants and viewers have no expectation of privacy. And by continuing to be in this meeting, you are consenting to being recorded. This recording will be posted on the Tax Review Board's website. With me today is our board chair, Paula Weiss, as well as board members John O'Connor, Nancy Cameradiner, and Ryan Boyer. Paula, please take it away.
Good afternoon, everyone. Tax Review Board for April 3rd, 2025 is now in session. We're going to move right into our docket for today, starting with 1512-16 North Broad Street. There are 4 companion cases. What are listed is 2, 3, 4, 5 on our docket. Case number 2, last 4 digits of the docket, 6640. Case number 3 on our docket, last 4 digits of the docket, 9198. Case number 4, last 4 digits of the docket, 9197. Case number 5, last 4 digits of the docket, 6641, all belonging to the Original Apostolic Faith Church. I believe there is an attorney on our Zoom representing them, Mr. Rabinovich. Is that correct?
Yes,
Okay.
I do.
Just identify yourself for the record now that we're recording.
Yes, my name is Jason Rabinovich. I represent the Original Apostolic Faith Church of the Lord Jesus Christ, Inc.
Thank you. And who has this matter for the city?
Michael Rulo, RULLO.
Good afternoon, Mr. Rulo. So, Mr. Rabinovich, I think the way we're going to start this is we like to get the dollar amounts and dates that are in controversy on our record, and then come back to you for you to give us an opening statement and present your evidence. Okay? So we're going to.
If it would please the board, I emailed this earlier. I would ask for a continuance request on this, and I've spoken to the city attorney about this. I'm in the middle of what is now turning into a 6-day federal court trial, which was not expected to continue this late. So I'm currently in recess. I asked the judge to allow me to sit here for this Zoom. From what I understand from talking to the city's attorney, Mr. Rulo, he expects this to last at least several hours to put on a significant record. And unfortunately, because of the time constraint with my federal court trial, I would ask for a very brief continuance to the next available date so that we could establish the proper record for this hearing.
And if I may add to that briefly, Supervisor Rybakowski, who is the witness in these cases, as you know, attends Board of Building Standards cases prior to TBR listings at 1 p.m.
TRB.
Yes, Tier B. In my experience, he is rarely, if ever, late from those. I received a communication from him a few minutes ago that he has 6 cases remaining.
Well,
So for both of these cases, I unfortunately do not have a witness.
Okay. So let me state for the record that this matter had a date certain, Mr. Rabinovich. We have been very patient. This wastes a lot of time for us. We could have had 4 other petitioners who have been waiting for their date for a hearing to resolve their issues scheduled today. And they are now bumped to some other date. And so while I guess the board will have a brief conversation, and it does seem like this continuance needs to be granted today, but this is the end. This is truly the end. This has got to be tried at whatever the next date is, and we're not going to entertain any more continuances, listings, anything.
I fully appreciate that. And I think
you were involved in picking this date. And I know that sometimes trials go later than expected, but this was at your convenience, not our convenience. And now we are inconvenienced.
I agree. And I apologize.
Any board members have any objection to a continuance today?
no.
To the next available listing. All right, that was Ryan Boyer, John O'Connor, Nancy.
I don't have any problems for today.
Always, I'll concur as well. Ms. Andre, how do you want to have this rescheduled?
Well, May has already been scheduled, so this will definitely be scheduled sometime in June. I would give Mr. if he could reach out to me with 2 Thursdays in June, that work, because we can only put L&I cases on Thursdays. So 2 Thursdays that work, and I'll schedule the one that's available.
Mr. Rubinovich, why don't you and I confer separately to make sure that those line up?
I agree. Yes,
And then contact Ms. Andre.
Please do.
understood.
Absolutely.
All right, so this matter is continued from today's docket. Thank
Thank
you,
you very
Mr. Rubinovich. We will see you in June.
Thank you.
And all right, Mr. Rulo, let's go back now. We've got, I understand your issue with Mr. Rubikowski, cases 1 and 7 for 1443 North 19th Street. Case number 1, last 4 digits of the docket R1RK. Case number 7, last 4 digits of the docket 1G03. And I believe that Mr. Pearl, this is your case?
It is.
Okay,
And-
so
If I may, because I want to own up to this,
Go ahead.
separate and apart from Supervisor Rybakowski's availability. In preparation for today's hearing, as you know, this was listed on March 17th for today. I used a prior list that did not have these on it, and that is entirely my fault. As a result, you may have noticed that we did not submit a position paper or exhibits. I have never done that before. It is completely unacceptable. I
you don't
apologize
have to
for
fall on
that.
your sword. It's okay.
And I would just ask for a brief continuance as I am horrified.
See, all right, because I was, okay, I think what I would like to do and maybe Mr. Pearl can help us out here. Could you frame out the issue here? Because I did see your court document and release, and without prejudicing the city, because I understand, Mr. Rulo, where you stand. I think even before we get to the next listing, assuming that that's where we're going here. So Mr. Pearl, could you just frame out the issue here that you're looking at?
I can, and I appreciate that. Thank you. My client is the owner of a property at 1443 North 19th Street. Adjacent to that property is a property that was owned or is still owned by the Redevelopment Authority. And that was at 14, and I apologize, 1441. Yeah. What happened is the Redevelopment Authority, as a result of their property falling into disrepair, and I think they call it a curbside demolition, a bid was issued, and the property of the RDA's property was taken down. In the L&I permit that was issued, it took down, and it's in their permit that says, as part of the taking down, it's taking down the party wall. The party wall is the wall between my client's property and the Redevelopment Authority's property. As a result of that, our building collapsed or started to collapse. We tried to rehabilitate it, and we could not. I gathered that the city then demolished our property, and that this is the lien that's there. We subsequently then filed an action against the Redevelopment Authority and the demolition contractor. The demolition contractor surprisingly took the position that the party wall was not a structural wall, even though that's the basis of a party wall. As a result, the city then, we came to a monetary settlement. I did offer that up as an exhibit, resulting in a $195,000 payment, $110,000 from the contractor and $85,000 from the Redevelopment Authority. As part of our release, we released the city, and the city asked for that. And so we understood, and we also did an SD&E. And as everybody's aware, the SD&E is for any claims that arose or could have arisen at that time.
Why don't you state that out as opposed to just the initial, so it's on the record?
Yeah. So after we signed the release, as part of the release, the release clearly says Philadelphia Redevelopment Authority, Mango Demolition, City of Philadelphia as well is a releasee. As a result, then on say it clearly, the case was finally dismissed on April 5th of 2023. where my client, we filed a discontinuance, settled discontinuing end, signed by all parties, on behalf by counsel. So it was our understanding that this was fully resolved, on both sides, same with the release. So we were a little surprised that subsequently we got a demolition bill from the city. We thought it was,
And
Part of
I
it.
have had a chance to review that. I'm going to suggest that the parties brief the issue of the interpretation of that agreement ahead of the next hearing, to be clear. As Mr. Pearl noted, it was a release from his client. There was no reciprocation in that, as I have understood the agreement. And while I would like some time to review the agreement and the other facts, I'm not sure if the city is going to agree with that position, which is why I think that fully briefing the issues in the position statements, respective position statements that we'll file, is particularly important in this case by both sides.
I-
Go ahead.
Can I just respond very quickly? And the reason, and obviously I appreciate where Mr. was coming from. When you file an SDNE, I can give the case law on that. As between the parties, the SDNE has the same effect of it's any claims that could have been raised or that were raised. So if
Okay.
this, and that's why we did the SDNE.
All right, so we're gonna hold it there because I think that Mr. Rullo is not gonna be prepared to fully respond, and I don't want to put him at a disadvantage. But I thank you, I was looking for that, and Mr. Pearl, I agree that I think having looked at the materials ahead of time, that this does look like a significant legal argument that we're gonna need to really review. What is
I'm-
the, go ahead.
If I may very quickly, and this is partially a question for Mr. Pearl, but I think it's relevant to everyone here. If there is a dispute over the meaning of the language in that agreement, typically that would be something that would require the intervention of the court in which that case was settled. So I'm wondering is if there is a dispute centered on that agreement, I believe we need to discuss if this is respectfully the proper forum for that discussion. And I
All right,
would
so let me ask
propose-
you a question and understanding that. So is the posture we're in today that all of this has gone on ahead of time? Court action, general release, payment, and now the city has come back and is expecting payment for the bills that were incurred in demolishing the property? Is that where we are? And
Yes,
so, okay, so Mr. Pearl, is Mr. Rullo correct in his assertion that this is really going to be, how do we interpret, or how does somebody interpret the release that was signed? I mean, we're not really arguing about the bills, is that correct? We're arguing about whether they're due and payable.
It's not the release, it's the SDNE.
Okay,
When you
So,
file,
but
when you file an SDNE, as a matter of law, it resolves all claims that were raised or could have been raised. And that's why this prevents what we're trying to do to the extent, not to sound legally, but entire controversy doctrine, et cetera. You don't think it to come back and say, wait a minute, I still have these other bills out here. That was
All right,
part
so-
of it. Yeah.
but I
Okay,
would just
so
note, and then we
that-
can move on, but the city was not a party to that litigation. We did.
Wait,
anyway,
part
let's
of the.
stop. I would just propose this.
all right, so we're not gonna argue today, that's fine. But, so I guess there are several questions. So clearly I mean, the bill, so the question, even whether we need Mr. Rubikowski, is not the validity of the bills, it's the question of whether or not this petitioner is required to pay, that has the legal responsibility to pay them in light of the SDA, the release, however you want to characterize what is controlling here. And then Mr. Rullo has now raised jurisdictional issues as to whether this is the correct forum.
Correct. And if I may, so that we can try and be efficient at the next hearing, I would propose that Mr. Pearl and I discuss 45 days before the next hearing, whether or not we have the same position on proper jurisdiction, because if it has to go to the Court of Common Pleas, then this matter would effectively be stayed. If we agree or come to, whatever, that this can proceed here, then I would suggest that 2 weeks before the next hearing, we would submit our position statements setting forth the legal arguments in that point, just so we're on the same page of timeline and I can be respectful of the board's time, unlike I was today.
Okay. Well, it sounds like we would be needing to do something like this anyway. Yes, I think that if Mr. Pearl is amenable, a conversation between the two of you outside of this forum as to whether or not you can agree on whether this is the proper forum or not would help. And if there is no agreement, or you both agree that this is the proper forum, then I would think even a letter brief from each of you, or a letter memo from each of you outlining your positions would be very helpful for us for the board as a beginning framework prior to a hearing. Mr. Pearl, what do you think?
Yeah, I'm fine with that. I can tell you, and this is the proper forum because of the SD&E. You cannot reopen your case. So what would happen is that my view is you'll have to hear it, and if somebody is unhappy with that decision, they have another remedy.
Well,
But
it's a right of appeal to the Court of Common Pleas. at that point.
Exactly. Right.
All right. So, provide us a letter memo,
Sure.
with that. Mr. Rulo, you will as well. Let's think about timing.
Absolutely.
I know that we're scheduled out to June already. We already had this conversation. So,
We could do something
say the
like
two of you-
10th
go
of
ahead.
July. If you guys, that is a ways away, but we could definitely, that could provide you guys with time to create the brief and send it to us, and then we could be ready to go. It could also allow for this to be the main case that day, and maybe the only case that day, which would also help with the flow of everything.
That's
It's
fine.
2 days before I leave for vacation, so that's perfect. I get to
Okay.
see Mr.
That's
Pearl
good.
and then get out of here.
So the 10th, if it's okay with everybody, I'd like to just pick this case up and move it to the 10th. And if you guys can get the board the brief, maybe by the 15th of June, that would be great.
What
And then
is
we
the
can have
date,
it on.
Melissa?
July 10th.
Thank you.
Okay,
That work for everybody?
You said July 15th, correct?
June
And-
15th to provide
Yeah.
the board the brief.
What-
May I ask if we could possibly I am on vacation in early June as well. Could we perhaps do, June 19th or 26th?
19th?
Yeah,
19th?
well,
That's
the
for
city
the
is
letter,
closed
for the
on
brief.
Juneteenth, so we're gonna go with the 20th.
Okay, that would be for the memo or the brief, or however you want to characterize it. And then
And I'll
July
put the
10th,
dates in- Oh, sorry, Paula.
and
I
then
just-
July 10th for the hearing.
Yeah, I'll put these dates in the continuance letter so everybody is aware. And if something does not work, please let me know so I could reschedule this as soon as possible.
Right.
Understood.
Or,
Thank
and,
you.
and, or if you have a conversation, when you have your conversation, if you reach an agreement on that in any way takes it out of our docket, just let us know that you're withdrawing the appeal, or that it's been moved or settled, or however it is you work it out. If other than that, we will just assume we're going forward.
Understood.
And Mr.
Okay,
Pearl,
so-
I apologize for the multiple Zooms. That was a scheduling issue on our part, so I apologize for that.
It's fine, only because my client was getting confused, so it created an issue, but I appreciate it, so thank you. No
Okay.
problem.
So I
Friendly
need,
problem child today.
it's all right. I need concurrence from board members that this matter will be continued as discussed.
Ryan
John
Boyer, I
O'Connor.
concur.
John
Ryan,
O'Connor, I concur.
Nancy Cameron, I concur.
Always, I concur. So thank you. Thank you, Mr. Pearl. Thank you, Mr. Lang, for your time and patience. I believe there's only one other matter that I did want to put on the record.
Be excused?
Hold on. I gotta find it.
Now
And
I'm-
that has to do with your case, Mr. Pearl. We had
Oh.
inadvertently duplicated the docket, so that what's listed as case number 6 on our docket, which has the last 4 digits PFMQ, has been administratively closed. It is not a live matter. And set for your information as well, Mr. Rulo. And
Yeah,
other than
because-
that, I believe
There's only one case then, I believe.
At
It's two.
2
Okay.
cases on our docket, cases 1 and 7.
Seven.
All right, so in any event, that completes our docket for today. Thank you all very much. We'll convene on Tuesday.
Thank you, everyone.
All right, everybody,
you.
take care. Thank you.
Bye-bye.
Bye-bye.
Bye,
Bye-bye.
everybody.
Take care, everyone.